I appear with Mr. Yetman for the appellant, my learned friends, Mr. Mills for the King's Counsel and Ms. Coyne for the Secretary of State. The appellant was represented below through the free representation unit and is now represented by Appellant. She's throughout been represented pro bono, and it's on that basis that the parties agreed, and I think the court has now sealed an order providing there be no order for costs of the appeal, regardless of the outcome.
Yes.
Could I check the court has the bundles that we hope you have? There is a core bundle and a supplementary bundle of documents, and then there is a large authorities bundle and a slim supplementary authorities bundle that was sent through yesterday.
Yes. Now the latter I've had in soft copy, but I was told we were going to get hard copies. So
I've got hard copies here.
as well, those are coming up. There are a lot of authorities, one or two of which I'm sure we will have to look at carefully. Others, I think, we are unlikely to. I'm bound to say we've all three obviously read it already with care. We see it's got a 2-day estimate.
We'll be done today.
Sorry?
We'll be done today.
That's what we thought.
Yeah.
Yes.
I anticipate I'll come subject to any questions the court may have. I ought to be comfortably done by lunchtime. Yeah. My learned friend indicated that he ought to need no more than 45 minutes or an hour, subject again to questions.
Well, that's very much what we expected, but I'm glad our expectations have been confirmed. So if we go over into tomorrow, it'll be our fault. That's basically.
The court will have seen that this case concerns provisions relating to bereavement benefits in the Social Security and Benefits Act 1992, and the compatibility of certain of those provisions with Article 14 of the European Convention, read with primarily Article 1 of the First Protocol. This, of course, isn't the first case relating to the compatibility of bereavement provisions in the 1992 Act with Article 14. Declarations of incompatibility with Article 14 were made in relation to widows' bereavement allowance in the case of Wilkinson, and in relation to widowed parents' allowance in McLaughlin. The particular bereavement provisions that we're concerned with are found in sections 36 and 39B of the 1992 Act, that is, bereavement payment and bereavement allowance. And we allege that those provisions are discriminatory in relation to heterosexuals. By way of introduction, could I attempt to encapsulate my case in 8 short points? First, sections 1 and 3 of the Civil Partnerships Act, in combination with the Marriage Same-Sex Couples Act, created discrimination against heterosexuals in relation to the right to register partnerships. That was the Supreme Court's judgment in Steinfeld. Second, Schedule 24 to the Civil Partnerships Act inserted and applied that discrimination into the Social Security and Benefits Act 1992 in relation to bereavement benefits. And it did so through an eligibility criterion that was available for homosexual people, but not heterosexual people. That's the civil partnership gateway to bereavement benefits. Now, having tied myself in knots over this in preparing the case, on reflection, I accept that this constitutes direct discrimination rather than indirect discrimination.
Is this your point 3?
That's still my point 2. I'm just trailing a point I'm going to take later. I just wanted to explain from the outset that I accept it's direct. I'll explain why, if I may, when I get to the points, it doesn't
Do,
affect.
but that comes as a relief because that was the view that I'd reached as well. And
Well,
but
that comes as a
you
relief to
seemed
me.
so confident about it. I thought, well, if Mr. Butler thinks this is the case, I must have got it wrong.
No, no. I should say though that doesn't affect the rest of the analysis in our skeleton. And what one can simply do when reading the skeleton is just strike through the words indirect and write indirect. That's point 2. Point 3, by way of introduction, the bereavement benefit provisions of the 92 Act ceased to be relevant to deaths after the 6th of April 2017 by virtue of the Pensions Act 2014. And so the discrimination was removed from the 92 Act prospectively.
I'm sure you're right about that, but can I had thought that Section 30 of the Pensions Act, as first enacted, likewise gave the replacement benefits only to those in married or in civil partnerships.
That's right. So I think it's right to say that on my analysis, one gets new discrimination through the Pensions Act. Yes. The only point I'm making for the purposes of my third point is that the Pensions Act removed the discrimination from the 92 Act.
Yes,
with effect from the 6th of April 2017. My fourth point is that the legislative provisions that discriminate...
Sorry, just give me one moment. Yes, so sorry, go on, yeah.
Point 4, the legislative provisions that discriminated against the appellant remain in force by virtue of transitional provisions. And I'll come on to show the court the detail of that. But for example, for someone who made a claim for payment before the 6th of April 2017...
Again, so I'll just take this education speed. Because there's lots of points which are basically seem to be common ground in the skeletons, but this is one where we're going to show us in detail because it's not common ground. Yeah.
Yes. So okay. For someone who made a claim for payment, like the appellant, before the 6th of April 17, and hasn't received the payment, the legislation remains in force.
Remains in force in what sense?
Well, in that the transitional provisions say that the legislation continues to apply to that person.
Yes, but if the right is there's a time limit on when you can claim, isn't there?
Time limit on when you can claim, and I'll take the court to that. If you've made the claim in time, but let's say through administrative oversight, haven't received it, the legislation remains in force for you. And I'll come to say in due course, that we say is the proper comparator for the appellant, because she made an in-time application. Obviously, she couldn't be paid because of the allegedly discriminatory provision. But if she had qualified, she'd had a claim. And if it hadn't been paid, she would still have a claim.
So that's point 4.
That's point 4. Point 5, in Steinfeld, the Supreme Court identified that there was discrimination in relation to the right to register partnerships, but it said nothing about discrimination in terms of accessing bereavement benefits. So the Supreme Court made a declaration of incompatibility in relation to sections 1 and 3 of the Civil Partnership Act, but not in relation to Schedule 24. to Civil Partnership Act, which inserted the amendments to sections 36 and 39B of the 1992 Act. And point 6, relatedly then, when Parliament remedied the discrimination declared in Steinfeld, there's no indication that it considered remedying the discrimination in relation to accessing bereavement benefits. Point 7, in those circumstances, we say that the respondent is wrong to contend that any declaration of incompatibility that this court would make would be the same declaration that was made in Steinfeld. In short, the declaration that we seek relates to a different thing, benefits, not civil partnership, and relates to a different legislative provision. Point 8, McLaughlin's provides a useful comparison. As I've already indicated, it was another bereavement benefits case. As here, by the time that case had got to the Supreme Court, the Pension Act had removed the discrimination prospectively. At least in the same way as I identified prospective removal in answer to my Lord's question. But because the legislation remained on the statute books, pursuant to transitional provisions, it was appropriate to make a declaration of incompatibility.
Did they actually address this particular question?
It's referred to by Baroness Hale, and I'll show the court that passage. It's not dealt with in any depth.
The point I made to you earlier would also have applied here, wouldn't it? It wouldn't have been in any sense academic, because until the statute allowing heterosexual civil partnerships, or actually a wrinkle here, until the introduction of cohabiting couples, it would still have been a live point anyway. So that by making a declaration of incompatibility about the older statute in that case, that would in practice have applied to the equivalent provisions of the current statute.
The court said in terms that it wasn't commenting on the position in the current statute.
Precisely. Okay, well, fine. Let's nest ahead of ourselves. We'll look at that when we get there.
But also, just to trail the point, the position was the same. In answer to my Lord's earlier question, the position was the same in McLaughlin as here, in that there was a limitation period for making claims. And that limitation period, that primary limitation period, had expired by the time the case got to the Supreme Court. Now, in response to that declaration, Parliament then made a remedial order that had retrospective effect. And in our submission, a declaration of incompatibility in this case would have the same utility as in McLaughlin. It would give Parliament an opportunity, if it thought appropriate, to remedy past discrimination that remains on the statute books pursuant to transitional provisions. Those are my 8
Thank you.
points. Could I please just give the court an outline structure of my submissions? I propose to cover 5 topics. Topic 1, the statutory provisions. Topic 2, McLaughlin. Topic 3, I propose to identify the components of Article 14, ambit status, relevant treatment, proportionality. 4th, I propose to look at the differences between the declaration of incompatibility in Steinfeld and the one that we seek in this case. And then fifth and finally, I propose to address the question, does it matter that only a relatively small number of people would stand to benefit from a declaration? So topic 1, the statutory framework. Could I begin, please, with authorities, tab 2, page 16. This is section 36 of the 92 Act. So this is bereavement payments, and could I make 4 short points about this? The first is the sum. It's not contained in this provision, but if I could just tell the court what it is, it's by reference to paragraph 1 of Schedule 4 to the Act. Insofar as that's in force, it provides for a one-off payment of £2,000.
Where do we find that?
That's the reference to that, which I'm afraid we haven't got.
Doesn't matter. No, just so for my note.
Schedule 4, paragraph 1.
Okay, thank you.
The second point about this is that, as one can see, it's a precondition to payments that there's been the death of a spouse or civil partner. Subsection 1. My third observation is that if one looks at the second footnote, one can see that the words "or civil partner" were inserted by paragraph 16(2) of Schedule 24 to the Civil Partnership Act. Fourth point, what's the time limit for making a claim? I'm afraid this is a bit of a paper chase. This is in the supplementary authorities. Page 2. Here we've got section 1 of the Social Security Administration Act 1992, and subsection 1A. One can see that a claim must be brought within the time specified by regulations.
Sorry, page
2,
page.
Supplementary authority.
Yes, okay.
Section 1(a), claims have to be brought within the time prescribed by regulations. The relevant regulation is in the same bundle, supplementary authorities.
Milford and I are very. It wasn't you. Sorry, it wasn't you, Mr. Milford. No, I've just handed down a judgment on this very subsection, this very provision, but on a different point. And I was thinking Mr. Milford was in it, but he wasn't. Sorry, do you go on?
Same bundle, page 20. These are the regulations that are made for the purposes of section 1. And this is regulation 19 of the claims and payments regulations. If we begin, please, at page 21, one can see paragraph 3, capital A, at the top of that page. The deadline for bereavement payment was 12 months from the date of death. But that's subject to the extension which is provided for by paragraph 3b, where the spouse doesn't learn about the death until later, time runs from the date of discovery. So I'll show the court the primary legislation that it cross refers to, but just to give an example, if someone goes missing and the body is only discovered years later, or death is only declared years later, then time runs from that point.
You're welcome to show us the provisions. Yes. I doubt whether we really need to see them.
No, I don't think you need to. Just for the court's reference, is at page 5 of this bundle. It's section 3 of the Administration Act. Now, the court may regard this as being a slightly pedantic point, but just for completeness, the court will note that paragraph 3b refers to bereavement benefit, not to bereavement payment. Bereavement benefit is defined by Regulation 2, which we've got at page 17. That cross-refers to section 20 of the Contributions and Benefits Act. That we've got at page 7 of this bundle, and it's subsection 1EA that defines bereavement benefit as including bereavement payment and bereavement allowance.
Thank you.
I could take the court through the pages.
I would be very happy not to.
So that's what I wanted to say about section 36 and the time limit for making claims under section 36. Could I then please turn back to the main authorities bundle and look at section 39B. This is at page 18. This is bereavement allowance, where there are no dependent children. And could I make 5 short points about this? First, if one looks at subsection 3, one sees that it's a weekly...
Sorry, section 39...
39 capital B, page 18.
Page 18. Thank you. Yeah.
First point, pursuant to subsection 3, this is a weekly benefit payable for 52 weeks. Second point, as set out in subsection 2, the rate is set by section 39 capital C. That we haven't got in the bundle. I can tell the court that provides for the amount to be prescribed by regulations, and that was done by regulation 3. Again, we haven't got this, I'm afraid. Regulation 3 of what's called the Rate of Bereavement Benefits Regulations 2010. And as at the 6th of April 2017, the rate was £112.55 per week. Third point, as with section 36, it's a precondition to payment that there's been the death of a spouse or civil partner. That's subsection 1. Fourth, again, if we look at footnote 2, page 19, we see that the words or civil partner were inserted, this time by paragraph 21.2, Schedule 24 to the Civil Partnership Act. And then point 5, what's the time limit for making a claim under 39B? Could we again please look at the supplementary authorities? And if we could this time go straight to regulation 19, this is page 20. This time it's regulation 19 paragraph 2 that's applicable, and the claim has to be made within 3 months. Again, that's subject to the possibility of an extension under regulation 19.3b. I've already shown the court. Those provisions were repealed subject to transitional provisions. The repealing provision is the main authorities bundle, tab 9, page 81, section 31, subsection 5 gives effect to Schedule 16. Schedule 16.
Hang on.
At page 81, behind tab 9.
31.5.
31.5.
Yep.
Schedule 16. Schedule 16 is at page 83. Paragraph 8 repeals bereavement payment. Page 84, paragraph 13 repeals bereavement allowance. The transitional provisions are at tab 10. We could look, please, at page 86. One sees at Article 3, paragraph 2, that the provisions for the repeal of bereavement payment and bereavement allowance come into force on the 6th of April 2017, but that's subject to Articles 4 and 5. Article 4.1.
So subsection 1 of section 3 is the one repealing the provisions of the 1992 Act. Isn't that right?
It's 3.2.
Yeah, I know you read 3.2, but I just thought we wanted to read 3.1 as well. 3.1 gives the commencement for the repeal for the provisions that you just took us to before. Mr. Milford says...
I'm so sorry, I'm going to say that the repeal is enacted by Schedule 16 to the Pensions Act 2014. That's at tab 9 of your authorities, pages 83 to 84.
Yes, but there's a question of when that comes in, that repeal comes into force, so that's what's dealt with by subsection 1, isn't it?
No, it's dealt with by 3.2. I understood it. 3.1 is dealing with the replacement provisions.
Oh, I see. Okay. But they're nevertheless, they're a pair, obviously.
They're a pair.
Yes.
Yes,
Yeah.
so you repeal
okay,
the old.
now I understand. Thank you.
It's the out with the old at 3.2.
Yeah.
And then Article 4.1, the repealing provisions don't come into force for a person to whom Article 4 applies. And then overleaf Article 4.4, the repealing provisions then do come into force for a person when the article ceases to apply to him or her. Now, we then get to one of the questions in the appeal, which is whether any part of Article 4 is still capable of applying to anyone today. Could I begin, please, with the application of Article 4 to bereavement payments?
Hang on 1 second. So, where do you want to go?
I just want to flag that I'm going to deal first with the application of Article 4 to bereavement payments. And I propose to deal with it in 2 points. First point, if we look at Article 4.2b, the article applies if the person would have been entitled to the benefit if they'd claimed it. But that's subject to Article 4.3b.
Hang on 1 second. Yeah.
So 4.2b, if the person would have been entitled to the benefit if they claimed it, subject to 4.3b, the article ceases to apply if they would no longer be entitled to the benefit if they claimed it. Now, as we saw by reference to Regulation 19.3b of the 1987 regulations, claims can only now be made for previously undiscovered deaths. And it's only to that extent that this bit of Article 4 remains in force. There's a second aspect of Article 4, and that's Article 4.2a Roman 1. 4.2a1. The article applies if the person was entitled to a bereavement payment on the 5th of April 2017. That has to be read with Article 4.3a. The article will cease to apply once the person is no longer entitled to that payment. Now, in my submission, they will only no longer be entitled to that payment if it's been paid. In any case in which the payment hasn't been made, whether that's through administrative oversight or something else, the article will continue to apply and the individual is entitled to rely on their statutory right to payment. Now, in relation to the two situations that I've identified, undiscovered deaths and payments still owing, we don't know how many such...
Hang on 1 second. Yeah.
We don't know how many such individuals there may be. But my point is one of principle. As a matter of principle, Section 36 remains applicable in such cases. Now, of those two situations that I've identified, it's the second situation, entitled to the benefit but not yet been paid the benefit, that is the hypothetical comparator for the appellant.
Yep.
And that's because she had applied for the payment before the 5th of April 2017. And but for the alleged discrimination, she would now, today, have a subsisting entitlement to payment. But for the discrimination, Section 36 would continue to apply. I've shown the court how in my submission Article 4 continues to apply in respect of bereavement payments.
Yeah.
Can I now turn please to bereavement allowance? It's effectively the same exercise I've just been through. First point, if one begins with Article 4.2b, that provides that the article applies to a person who would have been entitled to a bereavement allowance on the 5th of April 17 if they'd applied for it. But that's subject again to 4.3b. The article ceases to apply if this person would no longer be entitled to the allowance if they claimed it. And it's the same point. Again, by virtue of Regulation 19.3b, this remains in force in relation to bereavement allowance, in relation to undiscovered deaths. And the second point in relation to bereavement allowance, Article 4.2a.2 and 4.3a provide that the article continues to apply to a person who was entitled to a bereavement allowance on the 5th of April 17 but hasn't received that payment. And again, we say that's the hypothetical comparator for the appellant. Now, if I could take stock in relation to the legislative provisions as we say they remain in force, the relevant qualifying conditions are that first, the partner died on or before the 5th of April 17. And second, that the applicant was married to or in a civil partnership with the deceased partner. So that, for our purposes, those are the relevant qualifying conditions. And it's important that the first condition is important. It's got to have been a death on or before the 5th of April 17. Now, as we know from Stein...
Sorry, Mr. Butler, I didn't get the second condition.
Yes.
It's my fault. I was taking another note.
Sorry, my lady.
No, don't apologise. It's my fault.
So first one died on or before the 5th of April 17. Second one was married to or in a civil partnership with the deceased partner.
Thank you.
We know from Steinfeld that on the 12th of December 2019, the Civil Partnership Act was amended to allow heterosexual partners to enter into civil partnerships. But that had no application to sections 36 and 39b as they remained in force, because they required the death to have taken place on or before the 5th of April 17. And so, for the purposes of sections 36 and 39b, as they remain in force, the civil partnership gateway is only accessible by a homosexual applicant. That was what I wanted to say about the legislation, so that's my topic one. Topic two, I'm going to say something, if I may, about McLaughlin. Now, the alleged breach of Article 14 in our case occurred on the 23rd of February 17, when the claim was refused. That was the alleged discrimination, that was the alleged breach of convention rights. We accept that no further cases of alleged discrimination could arise after the 6th of April 17, by virtue of the Pensions Act 2014 and the transitional provisions. So I ask the question to myself, does the fact that the discrimination has been remedied prospectively, does that mean that it will be inappropriate to grant a declaration of incompatibility? And we say that the answer to that is no, applying McLaughlin. Now, before I turn it up, could I just explain what McLaughlin was about? The court probably knows. It concerned another bereavement benefit, widowed parents' allowance, under 39A of the 1992 Act. It concerned the Northern Irish version of the Act, but the relevant provisions are the same. The discrimination was against unmarried partners, and in the context of a benefit that assisted children, because this is widowed parents' allowance, that discrimination was unjustified. Now, the discrimination in Ms. McLaughlin's case had occurred on the 29th of January 2014, which is when the government refused to pay her a widowed parents' allowance on the ground that she wasn't married. The case came before the Supreme Court on the 30th of April 2018. And by that time, Section 39A had been amended in a similar way to the amendments of Sections 36 and 39B that we've looked at.
Sorry, I'm being slow. Namely,
It had been, it had no prospective effect, but there were.
we said amended. You mean repealed?
It had been amended. I can show the court in a
Okay.
moment. It had been done slightly differently,
I see.
in that it had been amended to do what the transitional provisions do in our case, to say that it now only applies to deaths that occurred before, in that case, it was the 10th of March 2017 rather than 6th of April 2017. It's the same legislative device, it's just contained, it's done by way of amendment of the primary legislation rather than through repeal and transitional provisions.
Hang on one sec. No, don't worry.
It's
Just
easiest if I hand up a copy in a moment.
no, but I just want to write a note to myself. Yes.
In fact, I think probably now is the time to do that. So what I'm handing up is Section 39, capital A of the 1992 Act, as it was in force at the time of the Supreme Court hearing in McLaughlin. And so one sees at Section 39A, subsection 1, that the way in which the legislation was amended was to provide that the spouse or civil partner had to have died before the date on which the Pensions Act came into force, and that date is the 10th of March 2017. And that's why I say it's in effect doing the same thing as the transitional provisions in our case. Now, the deadline for making claims in respect of deaths prior to the 10th of March 2017 had long since passed by the time the Supreme Court heard the case. And we can see that it's the same regulation that we looked at earlier in the supplementary authorities at page 20. Regulation 19.2, the 3-month time limit applied to widowed parents' allowance because that's a bereavement benefit. Subject only, as in our case, to Regulation 19.3b.
This is actually the Great Britain.
It is, sorry.
But you're saying there was
it's
equivalent on
it's
that,
the same in Northern Ireland.
which we haven't got. I'm not.
No, we can
not,
provide
not
it.
sorry.
We can provide it if the court
No,
wants
not-
to see it.
Want it for form's sake?
Yes.
I think it'd be useful to have it. Yes.
We'll do that. And so, in my submission, by the time the matter came before the Supreme Court, no new instances of discrimination could arise because the legislation only applied to deaths before the 10th of March 2017, and the deadline for making claims in respect of deaths prior to the 10th of March 17 had passed, subject only to the difficulty establishing cause of death provision. Now, as I read it, and I am going to show the court McLaughlin in a moment, as I read it, the Supreme Court considered it appropriate to grant a declaration of incompatibility because, but for the discriminatory rule, Miss McLaughlin would still have been entitled to receive the benefit. Which, of course, is the position.
Hang on. Okay.
Which we say is the position in our case. So McLaughlin is in the main bundle of authorities at tab 27.
Just hang on 1 second. I'm right in thinking, aren't I, that this McLaughlin limb of your argument doesn't feature in your certain argument.
That's right. We did it in the skeleton by reference to Wilkinson, but actually Wilkinson isn't such a good example as McLaughlin because in Wilkinson the legislation, so far as we can tell, had completely been repealed. And so there's a tension between what the High Court did in Wilkinson and was effectively, we say, endorsed by the Court of Appeal in Wilkinson. There's a tension between that approach and what Lord Hobhouse said in the First Counties Trust case.
Hang on.
So
Thank you.
I sought to dodge that potential tension by going straight to McLaughlin.
Hang on 1 second. So in Wilkins, there was no equivalent to the effect of the transitional provisions.
So far as we've been able to ascertain. And what happened
Hang on
was
1
that
second. We haven't yet seen McLaughlin, where you say that this is point. It does appear explicitly. It hardly appears explicitly in Wilkinson at all. Only at first instance, and then not clear that it was in issue, and not even explicitly thereafter. So Wilkinson was weak authority from your point of view. Yeah,
I accept that.
Okay, well that's helpful. I was just wondering whether I hadn't read your skeleton properly, because this all seemed to me, it was news to me. But let's then go to McLaughlin.
So it's tab 27, page 697. And if the court would please read paragraphs 44 and 45. Now, I should explain, there is another distinction between our case and McLaughlin, which is that because McLaughlin was concerned with an allowance relating to children, it could last for up to 20 years. And so the legislation resulted in payments that would carry on being paid for many years after March 2017. But in my submission, that's not the relevant point. What matters is whether the legislation is enforced for any purposes, whether there can be future discrimination. And in relation to that, the position is the same in McLaughlin as in ours.
Yes, this isn't in the appeal cases, so we don't know to what extent the point was argued. But anyway, you said it doesn't really matter. Lady Hill is very
Lady Hill's
clear.
confronted it. So obviously I'll rely on that. It may be a convenient moment to turn up First County Trust and to look at what Lord Hobhouse said and see whether there's any tension between that and what Lady Hale did. This is tab 17. The court will know, of course, that this was a case about the compatibility of legislation relating to credit agreements and Article 6 and Article 1 of the First Protocol. Turn please to page 241. Please read paragraph 127.
Yes.
Now that passage is obiter, but I accept its correctness in that if legislation no longer exists, then there's nothing in respect of which to make a declaration of incompatibility.
No longer exists, you mean is no longer in force?
Yes, for any purposes.
Yep.
But what I say that McLaughlin shows is that if the legislation remains on the statute books and has a discriminatory effect against an applicant, then the court has the power to make a declaration of incompatibility. Even if no future cases of discrimination could arise. And in my submission, the position in our case is effectively the same as in McLaughlin. As I've already submitted, the alleged discrimination in our case occurred on the 23rd of February 2017, when the Secretary of State refused Mrs. Kelly's application for bereavement benefit and bereavement allowance. From the 6th of April 2017, the discriminatory legislation no longer applied to new cases, and that's subject to the exception for late claims where cause of death is difficult to establish. Subject to that, no new claims could be brought. But for the discriminatory rule, Mrs. Kelly would now be entitled to payment of a bereavement payment and a bereavement allowance. But for the discriminatory rule, a position under Article 4 of the transitional order would be that she is entitled to the benefit. And so in my submission, if the court accepts that the rule constitutes unjustified discrimination under Article 14, then a declaration of incompatibilities is appropriate in this case, in exactly the same way that it was appropriate in McLaughlin. Could I then please show the court how Parliament responded to the declaration of incompatibility in McLaughlin? The remedial order is in the supplementary authorities. At page 24. Just to explain, this remedial order was remedying two different declarations of incompatibility. The one that was made by the Supreme Court in McLaughlin and the one that was made by the High Court in a case called Jackson. McLaughlin, widow parents allowance, Jackson, bereavement payment allowance. So when one sees in this remedial order references to bereavement payment allowance, that's remedying the Jackson incompatibility. If we could look please at page 31. One can see how the incompatibility was addressed. Article 5(2)(a), an additional eligibility gateway was added, cohabiting partner. And then we get the definition of cohabiting partner at page 32. Letter J after subsection 5 insert, and then new paragraph 7 gives the definition of cohabiting partner.
That's fine for completeness, but nothing turns on the definition.
It's just for completeness. But this is the bit I wanted to get to. How did the remedial order address the fact that it was now too late to bring a claim? And we see that at page 27.
Hang on 1 second. page?
Page 27. And the relevant provisions are Article 3.4 and Article 3.5a. And so we saw earlier that the 3-month time limit is contained in Regulation 19.2 of the 1987 regulations. And what Article 3.5a does is it changes that 3-month time limit to 21 months from the date of the remedial order.
Just talk us through how paragraph 4 works. Whereas 5 and 6 apply where, apart from satisfying the condition of making a claim, the claimant is entitled to bereavement support payment as a result of this order in relation to a death which occurred before the date the order comes into force. That's fine. What does apart from satisfying the condition of making a claim mean?
That they've got to have been in a relationship with the deceased, and there may be a few other bits and pieces in 39A that I've not looked at. But as long as the rest of the conditions are satisfied, then the fact that you haven't made a claim in time isn't a bar.
Oh, sorry, I've been slow. The key word is making. Yeah. Oh. No, I got it. I was just being slow.
Now, of course, I'm not asking this court to identify how Parliament might go about making a remedial order. That's entirely a matter for Parliament. But if a declaration of incompatibility were granted in relation to sections 36 and 39B, then it would be open to Parliament to make a similar kind of remedial order to this one. So, for example, it could amend the eligibility criteria to add a provision for a person who the Secretary of State is satisfied would have entered into a civil partnership with the deceased, had that been available to heterosexual couples, and then it could amend the deadline for claims. That would be one way of doing it.
One oddity about this is that as you say, it's not an objective matter like being a cohabiting partner. I say it's objective, even that involves an element of evaluation, but still it's an evaluation which it's thought people can make. This involves effectively a hypothetical prediction about whether someone would have taken advantage of the opportunity to become a civil partner had it been available.
Yes, I entirely accept it requires a judgment on a hypothetical. But it's, in my submission, not very much more difficult than the question that's posed by this remedial order, which is whereby the Secretary of State has to ask him or herself, in respect of a death that took place many years ago, was that couple living as if they were married or in a civil partnership?
And I'm not sure how this fits in, but an oddity that occurred to me as I was reading through is that the passing of the 2019 remedial legislation in relation to availability, the post-Steinberg legislation, doesn't immediately mean that people who could have claimed some benefit as a civil partner cease to be discriminated against, because you can't immediately become a civil partner on day one. You'd have to have some concept of a reasonable period in which you could, now is available, have been expected to acquire civil partnership status. I don't know where that goes. I really just put it out there. It's rather in the same territory as the point we're just looking at.
But it would be a point that would arise, I suspect, in relation to a claim targeting the Pensions Act 2014. Well, it would have to be. It couldn't be targeting this legislation because it only concerns a period up to
No, quite.
6th of April 2017. But yes, I mean, if my Lord's point is a good one, then it would provide a basis for seeking a declaration of incompatibility for a window of time, however long that might be, from the time that the 2019 Act came into force.
Well, it's certainly not our case, so perhaps we don't need to cudgel our brains about it, but I was provoked into thinking by you identifying what the eligibility criterion would be, and my observation that was a slightly different kind of eligibility criterion than the one in McLaughlin. But to which your answer is yes, maybe. Well, Parliament will have to decide what it wants to do about that.
Well, exactly, and so Parliament, it would be perfectly open to Parliament to say, well, this would require a different kind of remedial order to the one that we made in response to McLaughlin. We think actually that this form of remedial order would impose an undue administrative burden on the Secretary of State. Therefore, we're not going to make a remedial order.
Yeah.
But that's no reason for this court not to make a declaration of incompatibility, in my submission.
Okay, thank you.
So that's topic 2. Topic 3 then are the qualifying conditions discriminatory. As I've already submitted, we say that the applicable qualifying conditions are first that the partner died on or before the 5th of April 2017, and second, the applicant was married or in a civil partnership with the deceased. Now, those conditions we say disadvantage heterosexual couples because it was impossible on
Now, hang on 1 second. This isn't an issue, is it? That the qualifying conditions.
I don't think it is an issue.
You may still want to spell out why, because that may be relevant to your other arguments, but I just want to be clear about this. That's right, isn't it, Mr. Milford? It is not an issue that the qualifying conditions were in breach of Article 14. At the time. Or maybe it is. That I just
Well, my lord, it's not an issue that the Civil Partnership Act 2004 was in breach at the time of the claim. It is an issue that the qualifying conditions were necessarily breach of Article 14. I mean, one would have a our basic point is that the issue is that she was not able to become a civil partner.
I understand that, and
Yeah.
you're going to be developing
Yes.
that later. Well, let's not have the argument. Okay, I will park the question of what the extent to which this is common ground. I thought it was, but maybe I haven't thought it through enough. Okay, thank you.
So the conditions that I've identified, we say disadvantage heterosexual couples because it was impossible on or before the 5th of April 2017 for them to be in a civil partnership. And so they could only access the benefit and can only access the benefit via the marriage gateway.
And why is that a disadvantage?
Well, in practical terms, it's because of that cohort of people who don't want to get married but would want to get civilly partnered. Heterosexual people are disadvantaged in comparison to homosexual people.
Yes, I mean, I'm not expressing a view here. I just want to tease it out. What's wrong with getting what's wrong with getting married?
Well, it's the same point that was taken in Steinfeld.
Yeah.
On the facts of this case, it was for religious reasons.
Yes, I saw that. I was a bit puzzled, but and that the religious reasons extended to a civil marriage, to a marriage in a
No. Yes, to a civil marriage, but not to a civil partnership.
yes, but well,
But whether
I'm not going to go there because it's not what this case
whether
is about.
theologically well-founded or not, Judge Ward accepted
Yeah.
that was a
Yeah.
genuine viewpoint.
Yes, okay.
But
Okay, that's fine. I just wanted to tease that, but your straightforward answer is Steinberg. Was it Steinfeld?
Steinfeld.
Steinfeld.
Yes, that's my answer. But it may be helpful. I'm not going to take very long on this. Wasn't proposing to take very long on it. If I just unpack my submission by reference to the criteria for Article 14, the court will be well aware of the components, ambit, status, difference in treatment compared to those in an analogous situation, proportionality. Ambit, we say that the denial of access to bereavement benefit and allowance principally comes within the ambit of Article 1 of the First Protocol. I don't propose to turn it up, but just to give the court the reference, that was accepted in relation to bereavement benefits in McLaughlin, paragraph 16, page 689. Status, sexual orientation is a protected characteristic under Article 14. Again, just a reference. Steinfeld, paragraph 16, page 799.
Protected characteristic is a concept that comes from the Equality Act.
Sorry, my mangling of language.
Oh, sorry.
It's one of the features actually mentioned.
It's an other status.
Oh, it's an other status, is it? Yes.
Oh, well, I can't remember now. I think it's another status rather than an explicit status.
Probably actually thinking of the date of Article 14 is another status, but it's been well recognised.
It's well recognised. That's the Steinfeld reference. It's recognised as a status for the purpose of Article 14. What then about the nature of the discriminatory treatment? The thing that caused me some difficulty. In the grounds before the tribunal, Mr. Yetman put the case relating to sexual orientation discrimination as either direct or indirect. Again, just a reference, if I may. Core bundle, page 224, paragraphs 45 to 47. Now, my submission, it's got to be one or the other.
Well, has it? In Article 14, the traditional view of Strasbourg was they didn't really matter. They didn't care much about whether it was direct or indirect. Then as was reviewed in SC, the jurisdiction, the jurisprudence in Strasbourg has become a bit more sophisticated. But the great divide, which we have always recognised in our domestic legislation, direct and indirect, and you've got to be one or the other and can't be both, doesn't exist in Strasbourg.
No. It's well, let me put it this way. It's got to be discrimination for the purposes of Article 14 in my submission.
Yes. Whether
one says that it more neatly falls into the concept of direct or indirect.
Yeah. I mean, it seemed to me, as I was reading into this, a bit of a non-issue actually, whether it's direct or indirect, but it's still helpful to be accurate. So please continue with your.
Yes. Well, I may run into a sandbank in a moment, but my submission it's best looked at as a case of direct discrimination because the eligibility criteria were directly discriminatory in that the civil partnership gateway wasn't available to the appellant on the ground of her sexual orientation.
Yeah.
And what the respondent says in their skeleton argument, just to give you the reference, paragraph 47, subsection 1, they say, well, it can't be indirect because the civil partnership eligibility criterion isn't neutrally formulated.
Right.
Now, it may be that the court will think I'm going into this more than I need to, but perhaps if I could just turn up one authority, the case of James and Eastley in the supplementary authorities at page 39. I recognise the danger of looking at domestic concepts of discrimination, but it may help. So this is the case in which a council swimming pool gave free admission to those who had reached state retirement age, which at the time was 60 for women and 65 for men. And because state retirement age directly discriminated against men, albeit that was couldn't be attacked because it was in primary legislation, the entry criterion also directly discriminated against men, because one applies a directly discriminatory provision as a eligibility criterion, one ends up with direct discrimination. And just to show the court one passage, it's page 51. The judgment of Lord Bridge, who was part of the 3-2 majority. If one looks at page 51, just below letter H, halfway through the second line, Lord Bridge says, the statutory pensionable age being fixed at 60 for women and 65 for men is itself a criterion which directly discriminates between men and women in that it treats women more favourably than men on the ground of their sex. And then overleaf, top of page 52, last two words, the first line, it follows inevitably that any other differential treatment of men and women which adopts the same criterion must equally involve discrimination on the ground of sex. And in my submission, so too here. I just wanted to deal with two additional points on that. First is that in my submission, it would have made no difference if there had been an additional gateway to free admission to the council swimming pool, for example, for disabled people. The statutory retirement gateway would still have been directly discriminatory. And in my submission, it would have made no difference if the criterion had been and is receiving a state pension. Now that would have required an additional step to have gone through the formalities of applying for a state pension and getting a passbook. But such a criterion would still be directly discriminatory because men aged 60 to 65 couldn't take that step, but women could. In my submission, the same reasoning applies here. A homosexual person in an identical position to the appellant would have been able to satisfy the civil partnership eligibility gateway, would have been able to access bereavement benefits. The appellant, because she was heterosexual, couldn't. And that's not the way in which Judge Ward unpacked it, but in effect, as I read it, that's what he found. This is in the core bundle. encapsulated most neatly in his reasons for refusing permission to appeal, which is at page 111. And if the court would please read paragraph 11 on page 111.
Yeah.
So that's what I was proposing to say about it being direct discrimination. If I'm wrong and it's indirect discrimination, well, so be it. I'm content with that too. Final limb of Article 14, proportionality. In Steinfeld, the Supreme Court held that it was unjustified to make civil partnerships available to homosexual couples, but not heterosexual couples, in the period after the 13th of March 2014, when marriages were extended. And it must follow, we say, that the application of a civil partnership eligibility gave way in sections 36 and 39b, which relate only to deaths before the 6th of April 2017, is similarly unjustified. And again, it's not necessarily that clear, but that seems to have been the conclusion of Judge Ward. Perhaps I'll just give the court the references. It's page 90 of the core bundle, paragraphs 98 to 99. That's topic 3. Topic 4, has the discrimination already been addressed by the declaration of incompatibility in Steinfeld? We say that the answer to that is no, for 2 reasons. First, Steinfeld was concerned with the enjoyment of different rights. And second, Steinfeld was concerned with different statutory provisions. If I could take those points in turn. First, different rights. Could we please turn up the text of Article 14? It's perhaps a convenient place to do it is in McLaughlin, which is tab 27. Page 689. Baroness Hale sets out the text of Article 14 at the top of that page, paragraph 15. And the court will see that Article 14 requires the state to secure the enjoyment of other convention rights without discrimination. What enjoyment of rights are an issue in this case? Now, the answer is that the appellant wants to enjoy the right to pecuniary benefits, which principally falls within the ambit of A1P1. I just showed the court that, if we could look please on the same page, paragraph 16, line 4, in this case, it's clear that the denial of contributory social security benefit falls in the ambit of A1P1 in relation to the denial of widow's payment and widow's mother's allowance to widows. That must also apply to bereavement payment and bereavement allowance. Now, Baroness Hale went on to say that the benefit also fell within the ambit of Article 8. Then, if we look through to 691, if the court please read paragraph 23. Make the obvious point that A1P1 is safeguarding a different right. And then page 705, this is part of the dissenting judgment of Lord Hodge, albeit he agreed on ambit. And if the court would please look at paragraph 70, where he says, in my view, A1P1 is a more natural home for social security benefits, such as the widow parents allowance in Article 8, because it's a benefit which is directed to assist the bereaved widow / widower or civil partner who's lost the financial support of the deceased. He then goes on to say it's also in the ambit of Article 8. So whether or not Mrs. Kelly's claim to bereavement payment and bereavement allowance relates to the enjoyment of Article 8 rights as well, it certainly relates to the enjoyment of A1P1 rights. How does that compare to Steinfeld? Well, Steinfeld didn't concern access to benefits or the enjoyment of A1P1 rights. The claimant in that case wanted to enjoy the right to enter into a state-registered partnership other than marriage. And that fell within the ambit of the right to respect for family life. And Mrs. Kelly doesn't complain that she was unable to enter into a civil partnership per se. Her complaint is that she was unable to access bereavement benefits. Now, this is a statement of the obvious, but the declaration of incompatibility in Steinfeld said nothing about access to benefits or A1P1 rights. And Parliament therefore wasn't being asked to consider making a remedial order in relation to bereavement benefits.
Is it known to what extent the debate or the white paper or the considerations accompanying the remedial order have to be approved by both houses? Doesn't matter. Come back to that in a moment. Address the fact that civil partnership is not merely a status in its own right, but is the gateway to a very large number of other benefits with a small b, most obviously, however, benefits with a big B. If you thought about it, you would certainly appreciate that. It's pretty obvious. Was that, however, expressly taken into account in any of the formal procedures that led to the making of the order?
So far as we've seen, no indication, but my learned friend may be about to jump up and say otherwise.
Well, then he needn't jump up now. He can know this question will be interested in, or I will be interested in, when we get to his submissions. Okay, thank you.
So that was my first.
To interrupt the procedure for making a remedial order in paragraph 2 of Schedule 2 to the HRA. Quite complicated.
So does it involve both houses?
Yes, it's got to be approved by resolution of each house.
Yeah.
Yeah, paragraph 2 of Schedule 2 is that.
Yeah. So that one would assume that they, for all I know, it went
There's
through on the
also-
nod, but nevertheless, there will have been a parliamentary procedure, a formal, not just laid before.
And also there's provision for representations to be made and considered in paragraph 3, schedule 2. I mean, there's quite a elaborate procedure, there must be some documents about what was under discussion. Okay.
In Steinfeld itself, I can't remember, I haven't reread it for the purpose of this decision. In what I might call the general considerations about why it was disproportionate to discriminate between heterosexual and homosexual couples, you might have expected there to be something about this is an important status in practical terms as well as in merely theoretical terms.
Yes, and if they'd said, I accept that if the Supreme Court had said, of course, this isn't just about right to respect for family life, it has other important consequences, and here they are. And even if that hadn't been spelled out in the formal Declaration of Incompatibility, but that had gone to Parliament, then I might be in a different position to the one I'm in now. But the Supreme Court didn't do that.
Hang on 1 second. Thank you.
Because I accept that the court has a power, not a duty, to make a declaration of incompatibility. And if it's evident that it would be totally pointless to make a declaration of incompatibility, because albeit not through a previous declaration of incompatibility, but in substance, the Supreme Court has drawn the issue to Parliament's attention, then the court might conclude it, although it could in principle make a declaration, it's inappropriate to do so.
I suppose you've got the further point that the remedial order that was promulgated to address specific issues to do with benefits did make retrospective provision.
I'm so sorry.
Well, the remedial order that you've shown us that was designed to deal with 2 decisions of the court about benefits,
Yes.
Did make retrospective provision.
Yes.
And we're about the same time. I think what's the date of that order? McLaughlin-Jackson order.
23, I think.
Oh, no, a bit later then. No, I may have made a bad point there. I thought McLaughlin itself was 2018. That's what made me think it was the same time.
It took them a while to get around to it. The remedial order came into force on the 8th of February 2023.
Oh, right, okay. I mean, this doesn't undermine my lady's point, but the particular point that they must have been doing this at much the same time. Still think they might have been thinking about it at much the same time, because McLaughlin's 2018 and Steinfeld is 2019. Or even 20. When's the decision of the court? Also 2018, I think, actually. The decision of the court is
27th of June 2018.
And McLaughlin was August the 30th, 2018. Yeah.
But there doesn't seem to have been a joining of the dots in the documents that we've seen. So that was my first point, the nature of the treatment for the purposes of Article 14. My second point is the legislative source of the discrimination. And if we could look, please, at Section 4 of the Human Rights Act, Authority, tab 4, page 25. It's subsections 1 and 2 that relate to primary legislation. And subsection 1, we can see, refers to a provision of primary legislation. Subsection 2 refers to the provision being incompatible and empowers the court to make a declaration in respect of that incompatibility. And then overly subsection 6A, refers to the continuing operation of the provision. So, to make an obvious point, declarations of incompatibility are focused on particular statutory provisions. And a declaration of incompatibility draws Parliament's attention to that particular incompatibility.
And the focus is on the incompatibility of the provision of primary legislation with a convention right, which presumably must mean the convention right that's at issue in the proceedings.
Exactly, which, as I've endeavoured to identify, was in Steinfeld was Article 8 on its own. Article 14 read with Article 8. In our case, is Article 14 principally read with A1P1. Just on this point, that it's drawing Parliament's attention to a particular incompatibility, could I show the court a passage of Steinfeld, which is Authority tab 29, at page 810. And at paragraph 60, Lord Kerr cites his own judgment in Nicklinson. If the court would please read the whole of paragraph 60. So I ask the question, what's the relevant statutory provision in our case? The Secretary of State says that it's sections 1 and 3 of the Civil Partnership Act. We respectfully say that's wrong. Sections 1 and 3 created the institution of civil partnerships and defined those partnerships. But those provisions didn't amend the eligibility criteria for bereavement benefits. What changed the eligibility criteria for bereavement benefits? Well, perhaps I could just show the court. Supplementary authorities. Page 11. What changed it is section 254, subsection 1, which gave effect to Schedule 24. And then at page 12, we see paragraph 16.2 of Schedule 24, which inserted all civil partner into bereavement payments. And then at page 13, paragraph 21.2 inserted all civil partner into bereavement allowance.
Sorry. Yes, I see.
Now, of course, the meaning of civil partner was defined by reference to sections 1 and 3 of the Civil Partnership Act. But as I say, 1 and 3 alone wouldn't have had any impact on those seeking bereavement payments. And then, point I think I've already made, but sections 1 and 3 were then amended by the Civil Partnerships, Marriages and Deaths Act 2019 to extend them to heterosexual people. But that amendment had no practical application to section 36 and 39B of the 1992 Act, because by the time of the 2019 Act, the transitional order had been made, which confined sections 36 and 39B to deaths predating the 6th of April 2017. So by the time Mrs. Kelly's benefits claim was determined, the civil partnership gateway in sections 36 and 39B could only apply to homosexual couples. And as they remain in force now, can only apply to homosexual couples. And so it follows, we say, that the legislative source of the discrimination is sections 36 and 39B of the 1992 Act as amended by Schedule 24 of the Civil Partnership Act and as in force pursuant to the transitional order. By contrast, the declaration of incompatibility made in Steinfeld only related to sections 1 and 3 of the Civil Partnership Act. Just to give the court the reference, it's the last paragraph of Lord Kerr's judgment, paragraph 62, page 811. Nothing was said about the primary legislation at issue in these proceedings. And inevitably, we say that meant that the Minister and Parliament weren't asked to consider amending sections 36 and 39B as they remained in force.
And would they indeed have been empowered to under the section 10 procedure?
Yes, I think they would. Can I just, I think I better turn that up.
It's a pretty wide area.
Yeah, I think if it's a bad point.
It is. It's page 52 of the authority, tab 4, page 52. And one sees at paragraph 11A that a remedial order may contain supplemental provision
Yes, I see.
as the person considers appropriate.
And it also includes a power to amend primary legislation, including primary legislation other than that which contains the
Oh, yes.
It is pretty wide.
Okay, thank you.
So that was my topic 4. Fifth and finally, we accept that the incompatibility that we've identified won't affect all heterosexual people to whom this legislation applied. It will only affect those who would, but for the discrimination, have entered into a civil partnership. And that is liable to be a relatively small group of individuals. some of those individuals have brought appeals which are stayed behind this case. Could I just show the court the reference to that in Judge Ward's judgment? It's Court Bundle, page 63. Page 63, paragraph 6.
Yeah. And to be accurate, those are people who claim that they would have, I mean, not necessarily any bad faith, but it hasn't yet been established they would have. There might be some cases where the tribunal says no.
Yes. Now, in my submission, providing the claim is brought by an individual who has suffered a breach of his or her convention rights, it doesn't matter how many other people are affected. And can I show the court, please, authority on that? The first case is Nicklinson, which is authority tab 26.
Sorry, which tab?
Tab 26.
Is
What?
this judgment not reported?
Well,
I'm so sorry, my lady. It is reported. We can make reported copies available. There are a few judgments in here. I don't know how it's happened, where we've got the unreported versions.
Yeah, it's just a slip. And generally these are very nicely put together. But just to mention, as we have two distinguished counsel from distinguished sets of chambers here, what tends to happen these days is they're put together by people in chambers rather than by solicitors. They're not always as well trained as to what ought to go in a bundle as one would hope. I suspect this was just a mistake. And,
Yes, I think that's
all
right.
the same, it's no harm in just drawing it to the attention that it would have been on your side, I think.
No, well, it wasn't. In fact, now I should say that we're very grateful because of the funding arrangement.
Yes, I see. Yes,
the respondent kindly agreed to do it, and I wouldn't wish them to get too hard a time having volunteers.
I'm not giving anyone a hard time, simply because we have it often. Whenever it comes up, I do make this point, but sometimes I make it with real crossness. Not in this case. It's clearly just a slip. So
yes,
don't
yes,
worry at all.
it's reported in the appeal cases reports, and we, if anything turns on, we can provide copies of the.
I think it would be pointless for you to send it to us. It's extremely easy for us to find.
Thank you. I'm not going to go into the detail of the facts or the ratios, so I don't need to look at the head note. The appellant claimed that Section 2 of the Suicide Act was incompatible with his rights under Article 8. The majority held that it had that the court had jurisdiction to make a declaration of incompatibility, but declined to do so on the exceptional facts of the case. What I wanted to show you was part of the judgment of Lord Wilson, who was part of the majority, and that is at page 618. If the court would please read paragraph 203.
Yes.
So Lord Wilson's point was that Section 11C of the Matrimonial Causes Act would only give rise to incompatibility in a small number of cases to which that section applied. And if I could just ask you to turn up Bellinger so we can see the form of declaration that was made. It's tab 14. At page 142. At paragraph 70, we can see that the form of declaration made was an individualised declaration of incompatibility.
Yeah, well, Lord Hope didn't know what he was doing, but that strikes me as slightly inconsistent with the spirit of Section 10, Section 4, which is to say that the legislation is incompatible. This doesn't undermine your point that it's not incompatible in every case, but it's incompatible in some cases. But the focus on Mrs. Bellinger's individual right, I'd have thought was, if that's really what, as when it was eventually drafted, it said.
If one looks at page 145, one sees the declaration recorded at the end of the judgment.
Yes, no, I can see.
It is how it was framed.
Yes, well, there you are. If it was all right for the House of Lords, it's presumably all right for everyone else. But it still strikes me as slightly odd.
Well, it may be that one more authority would help then. Can I show the court AS Somalia, which is tab 22? Now, this case concerned a rule in primary legislation that post-decision evidence, so evidence that arose after the Secretary of State had made the immigration decision, couldn't be admitted in immigration appeal proceedings.
Yeah.
There was the House of Lords concluded there was no breach on the facts of that case because it would have been proportionate in that case to have used the new evidence to bring a fresh claim. But the court recognised that in some cases, because of the urgency of the individual circumstances, the delay in having to go through the fresh claim route would give rise to a breach of Article 8. And then if we could look, please, at page 450. Lord Hope again. Next to letter C, there's a sentence which begins, the delay resulting from the need to start the procedure again. If the court would please read from there until the end of Lord Hope's judgment.
Yes, well, it's the same point.
Same point. Now, we don't need an absolutely bespoke individual declaration. The submission I'm making is that it doesn't matter that there may be relatively few people to whom the incompatibility would apply.
Have you actually formulated anywhere the direction of incompatibility that you want?
We attempted to do so in the final paragraph of our skeleton.
Reminds me. The final paragraph, you said.
Final paragraph, making the important adjustment for direct rather than indirect.
You don't actually need the final phrase at all, do you?
No. because the reasoning will be supplied by the judgment.
Sorry?
The reasoning will be supplied by
Right.
the judgment. But it could equally.
Well, I would have thought. I'm just thinking aloud here. I'm sorry, I hadn't focused on this, but another way of doing it. I'm not saying you have. I would just say are incompatible with the appellant's rights. Sorry, are incompatible with Article 14 to the extent that they require the Secretary of State to refuse to pay a bereavement payment in respect of her partner's death to persons who would have been in a civil partnership had they been available. At the time. It's another way of doing it. It's not, to me, that something along those lines, I'm sure it could be improved.
My lord, I'd respect.
It sort of generalises the point in a way which avoids making this all a case about an individual, which is not really what Section 10 is about, though an individual brings it.
I respectfully agree that the version that my lord has just suggested would be an improvement.
I haven't noted it down, but I'm sure I can catch up later.
What I'd written down was are incompatible with Article 14 to the extent that they require the Secretary of State to refuse to pay to persons who would have been in a civil partnership had they been available to heterosexuals at the time.
Yeah. It may turn out to be rather mouthful, but it could just be fiddled around with. Well, it remains to be seen whether we get there.
Of course.
Yeah.
So if I could just attempt to draw the threads together. Mrs. Kelly, we say, was discriminated against in relation to her access to benefits. That discrimination was mandated by primary legislation. The courts have never previously made a declaration of incompatibility in respect of those benefits or that particular legislation. And we respectfully say that there's no principled basis for the court to decline to exercise its power to grant a declaration. To the contrary, as Lord Kerr said at paragraph 61 of Steinfeld, don't propose to turn it up unless you want to see it, that having been given the power by Parliament under Section 4 of the Human Rights Act, it would be wrong not to have recourse to that power. Unless the court has any further questions, those are my submissions.
I don't. Either of my ladies. Yes, thank you, Mr. Milford.
Thank you, my lord. So, my lord, we say that the claimant's case on sexual orientation discrimination below, as both we and the Upper Tribunal understood it, was that she suffered discrimination because she was unable to enter into a civil partnership with her partner before his death in December 2016, so that she wasn't in a position to claim bereavement allowance or bereavement payment. And we say, in substance, that was exactly the same complaint made in Steinfeld, that heterosexual couples should have been able to enter into civil partnerships, but were precluded by the terms of the Civil Partnership Act 2004 from doing so. And in circumstances where that issue was addressed and remedied, following the Supreme Court's decision in Steinfeld and Kaidan, and the Civil Partnership Act 2004 was amended from the 2nd of December 2019 to allow different sex partners to enter into civil partnerships. We say that there is no possible remedy that this court could or should give the claimant in that respect. Now, my learned friend today has reframed this as a complaint about what's said to be direct discrimination within Section 36 and Section 39B of the 92 Act.
Can we just be clear about that? He has reframed it as direct rather than indirect. Nothing, and also he has relied on different authority, namely McLaughlin.
Yes.
Subject to those 2 points, which are the margins rather than central, his point is the same as at least in his skeleton.
The point is the same, at least as in his skeleton. It's not quite the same as it was below. I'm not making my lord, let it be clear, I'm not suggesting that my learned friend shouldn't be able to make these points.
Right.
We say that a complaint about Section 36 and Section 39B doesn't work because it's either the same complaint about discrimination against cohabitees, which was already dismissed by the Upper Tribunal and which is unappealed. That is the difference in treatment between those who are married and civil partners on the one hand and cohabitees on the other. Or else it is the Steinfeld complaint. But there isn't a third way, if I can put it that way, albeit that my learned friend has put together a sort of subtle way in which he says this is legislation that remains in force and you can give a declaration of incompatibility in respect of it. We say that on a proper analysis, that third way does not exist. And if I can just unpack that, so there are two things that the claimant might be saying. She might be saying, I suffered discrimination because Section 36 and Section 39 applied to married persons and civil partners on the one hand and not cohabitees on the other. And the reason I was a cohabitee is because I couldn't become a civil partner even though I wanted to. If that were what was being said, then that would collapse back into the cohabitee complaint that was dismissed by the Upper Tribunal. There are many reasons why a person...
Hang on 1 second. Yes, sorry.
Yes, so my lord would have seen, I mean, from the Upper Tribunal's judgment that it considered in great detail why cohabitees on the one hand and married persons and civil partners on the other were not in an analogous situation, and why in any event, even if they were, any difference in treatment would have been justified.
That's the sort of ACTA point.
Yes.
Yeah.
Yes. But also addressed in the alternative on the basis that the judge was wrong on ACTA, went on to deal with justification and said anyway justified. Now, no doubt there are many reasons why people will be cohabitees. And one of them, at the relevant time, would have been that they were different sex partners who couldn't become civil partners. But that does not in itself add to a complaint about discrimination based on cohabitee status, we say. It only does so if really what you're complaining about is Steinfeld. But conversely, if what you're complaining about is the ambit of the term civil partner, as used in Section 36 and Section 39B of the 92 Act, that is precisely the Steinfeld complaint, because your complaint then has to be, I was a person in an opposite sex couple. I would have liked to become a civil partner, but I could not do so. And I would have done if I could. And that is Steinfeld. And that, we say, is really what the claimant is complaining about. And there isn't a third way, and a third way can't be found in section 36 and section 39b, because apart from anything else, the meaning of civil partner in those sections is determined by the Civil Partnership Act 2004. And when that act was amended following Steinfeld, so that the definition of civil partner changed, it changed also in section 36 and section 39b automatically, just as it changed in every other enactment where the term civil partner was used. And that being so, there's not any remaining incompatibility within section 36 and section 39b to be dealt with. There is a complaint, which my learned friend has made to you this morning, that she would have wished to become a civil partner at a time when she could not do so. But that is not a complaint about section 36 and section 39b, not a complaint about the terms of those sections. The terms of those sections, post 2nd of December 2019, are entirely compatible with convention rights. It's a complaint that at a point in the past, the problem identified in Steinfeld meant that she couldn't become a civil partner. And that means that her true complaint is about the consequences of past discrimination in the Civil Partnership Act 2004. What she seeks to do is to use the Declaration of Incompatibility as a mechanism to ask Parliament and the government to look at providing her with damages for past discrimination, in effect, because she couldn't become a civil partner at the time. And we say that is not an appropriate use of a declaration of incompatibility. And the answer to it, if answer the B, is one has to go off to Strasbourg. So that's what I say in a nutshell, my Lord. And what I propose to do is to address the court first on the premise that this is in reality a complaint about the discrimination identified in Steinfeld, and indicate why we say that should not lead to a further declaration of incompatibility that is effectively addressing the same issue that was addressed in Steinfeld. And then secondly, address my learned friend's arguments as to why this is discrimination which can be distinguished from Steinfeld. And as part of that, I'll also address McLaughlin, obviously, because we say that McLaughlin is not an analogous case when one looks at it. So can I start, my Lord, with the position, if this is really a complaint about the discrimination identified in Steinfeld, and it might be helpful just to turn up Steinfeld, which is at tab 29 of the authorities. One has the complaint identified in paragraphs 1 to 3 of Lord Kerr's speech. Claimants were an opposite sex couple who wished to become civil partners but were prevented from doing so by the terms of the Civil Partnership Act. So they same-sex couples had a choice that was denied to opposite-sex couples within the Act. And that was a difference in treatment which fell within the ambit of Article 8, read with Article 14. Worth just turning up, if we may, paragraph 13 on page 799. Because that goes to a point that my learned friend made to you earlier, which is, well, the court just wasn't aware of the fiscal consequences of all this. And I say the court actually was entirely aware of that, because that's exactly what the quoted passage from Lord Justice Briggs is concerned with.
Just give us a second to read that then. Yes, and well, there's a reference to serious fiscal disadvantage.
If one of them dies before.
Yes.
Yes.
It's not actually a reference to benefits, but it is a reference to something other than just wanting the status.
Yes, indeed, and that's also picked up in Lord Kerr's speech at paragraph 52. So that's page 809.
Second. Sorry, forgive me, I'm just making a note. Which paragraph?
So paragraph 52. So this is where Lord Kerr is considering the fair balance. If, contrary to his earlier finding, there was a legitimate objective at all, didn't strike a fair balance, and one of the things that would go into the balance when considering that would be the question of fiscal disadvantage. See the end of the paragraph.
Yep.
So we say this is something which was obviously on the court's radar, not least because it was obviously relevant to fair balance. And in fact, and I'll have to produce it over lunch, my lord, but when one looks at the preparatory papers before that were created before one had the amendments to the Civil Partnership Act in 2019 following Steinfeld, one of the things that is one of the topics that is addressed there is bereavement benefits. So,
right, well, that
yes.
will be interesting to see, and you can find that. That's impressive.
I'll make sure it's produced over lunch. So that is Steinfeld, and the logical point at which to start is then to look at the claimant's complaint as eventually framed in the Upper Tribunal and indeed as understood by the Upper Tribunal. And if one turns to pages 2 to 3 of the core bundle, this complaint starts at paragraph 41. Paragraph 41 says that discrimination arises because she was unable to enter into a civil partnership at the relevant time. So the need for her to enter into such a partnership as one route to obtain bereavement discriminates against her on the grounds of sexual orientation. Paragraph 44 actually quotes Steinfeld, and paragraph 45 on page 224 says that the reasoning in Steinfeld is applicable in the instant case, given that bereavement benefits provisions in effect crystallised the discriminatory operation of Section 1.1 of the Civil Partnership Act 2004. And we say that those paragraphs which reflect the way in which this claim was actually argued in the Upper Tribunal, that they are clearly in substance a repetition of the Steinfeld complaint. Because what's being said is, I should have been able to become an opposite sex civil partner. I couldn't do that as a result of the terms of the Civil Partnership Act. Therefore, as a result, I was unable to claim bereavement benefit. So I suffered detriment. And that comes back to my really first and overriding point, which is that this is about the consequences of the discrimination identified in Steinfeld. And logically, we say that must be the right and only way to approach the issue, because this can't be a complaint about the use of civil partnership as a basis for entitlement to bereavement benefit per se, unless the claimant herself can say that created a disadvantage for me because I would have become a civil partner but was unable to do so. And if that's what she's really complaining about, and we say it is, then it comes back to the Steinfeld point. The problem is not being able to become a civil partner. That is the anterior problem which creates the position in which the claimant now is. And that's how the Upper Tribunal understood this complaint. And in my submission, it was right to do so. And one sees that from paragraph 98 at page 90 of the core bundle. MK could have got married in a civil ceremony, if not a church, at any time from 2000 on, but chose not to.
So sorry, where are we?
I'm so sorry, my lord. Paragraph 98, page 90. Perhaps I could just ask you to read that paragraph.
Yeah.
So, my lord, on the premise that that is the complaint, and I'll obviously come back to address the alternative that's put to you by my learned friend, we say that there are 4 basic reasons why a declaration of incompatibility could and should not be granted. And the first is it wouldn't be a complaint about any provision of existing legislation. It would be a complaint about provisions of the Civil Partnership Act, which have already been considered by Parliament and the government and altered with effect from the 2nd of December 2019, so as to be consistent with convention rights. And, my lord, it might be helpful, I don't think we did this morning, but just quickly to take you through the mechanism by which that was done, unless you tell me that it's unnecessary to do so.
Do it.
So the starting point is the Civil Partnership, Marriages and Deaths Registration Act at tab 11 of the main authorities. And one can see by section 2 of that, at page 93, that the Secretary of State was given the power to amend the CPA so that 2 persons who are not of the same sex would be eligible to form a civil partnership in England and Wales.
Sorry, give me a second.
I'm so sorry, my lord.
Which tab are we in?
We're in tab 11.
Yeah.
Yes, so subsection 1 is the power given to the Secretary of State. Subsection 2 is the obligation to exercise that power no later than the 31st of December. So in effect, Parliament said to the Secretary of State, you must alter the Act then the relevant alteration is at tabs 3 and 4 of the authorities. No, I'm so sorry, my lord. Tabs 5 and 6. So at tab 5 on page 64, you've got the old version. A civil partnership is a relationship between two people of the same sex, in force up to the 1st of December. And by section 3 on page 66, two people are not eligible to register as civil partners of each other if A, they are not of the same sex. So that's where it stood until the 2nd of December. And then on the 2nd of December, the next version you have at the next tab, page 68, section 1.1 has been amended to say a civil partnership is a relationship between two people, civil partners. And then section 3, eligibility, on page 71, two people are not eligible to register as civil partners of each other if ... and one can see that 3.1a has been taken out. So that's how it happened. And so the relevant changes to make the legislation compatible with human rights were made by the 2nd of December 2019. And also just worth showing you one further thing, which is important for section 36 and 39, which is the Interpretation Act 1978, which you've got at tab 1 of the authorities. My lord, I saw you looking at the clock. Perhaps after this, would it be a logical point at which to...
Yes, it would.
So one sees by section 5, in any act, unless the contrary intention appears, words and expressions listed in Schedule 1 to this act are to be construed according to that schedule.
So sorry, which page are we at?
So this is page 4, the authorities, tab 1.
Yes, but
And
I
then
see. Yes, got it.
Yes.
Sorry. Yeah.
And then at page 6, civil partnership means a civil partnership which exists under or by virtue of the Civil Partnership Act 2004, and any reference to a civil partner is to be read accordingly.
Yeah.
So that's the point, the essential point we make about sections 36 and 39b. They use the term civil partner, but they use the term in the sense in which it's used in the Civil Partnership Act, so that changes automatically on the 2nd of December 2019.
Yes.
My lord,
That's.
shall I pause there?
Why not?
Yes.
If we say 2 o'clock, will that give you enough time to get out the travaux préparatoires?
We think it will, my lord, yes.
Well, that's fine. Given how well everyone has done, I was going to reward you with lunch if required, but if not required, you'd rather
Can
have
I
it.
just
You'd rather
check
have
behind
it
me?
later.
I will not be very long in my submissions.
No, so I gather.
It might be sensible just... My lord, if it was possible to have...
I think that would make more sense because you want to pass it past Mr. Butler as well. We'll say 2:15.
White paper civil partnership. What about the? I thought their question. I may